A hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
All right.
A tense bond hearing suddenly turns personal when a defense attorney suggests that prosecutors receive faster and better access to the court than defense counsel. The attorney argues that the alleged victim has not appeared to personally explain why she feels endangered and complains that the defense received only about 24 hours notice of the hearing. But the judge immediately rejects the implication that the court is playing favorites. According to the judge, defense attorneys routinely obtain emergency hearings when they file the proper motions and make the appropriate requests. The exchange becomes so heated that the judge orders a recess. When court resumes, the judge returns with nearly 25 years of experience behind a pointed response, calling the attorney's accusation one of the most insulting and ignorant statements ever directed at the court. Yet the biggest question is what happens to the client caught in the middle. Will the judge's anger influence the bond decision, or will the court separate the attorney's conduct from the defendant's rights? Stay with us, because the judge makes an unexpected decision designed to protect the client from being punished for counsel's courtroom mistake.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here with and I'm here. James Dennis Whitney.
This is people's emergency motion to modify bond in this case.
I find it surprising that they're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client
Call her to show up to do what?
today to say, I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to happen.
I don't know, at 3 o'clock, with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
All right.
Have you seen it? 13A District Court of County, Washington, out session, the hour of the day setting.
You may be seated. Court recalls the case of the People versus Whitman.
Assistant Prosecuting Attorney wants to have people.
Good afternoon, Your Honor. For the record, my name is Jeffrey Bennett. I'm here in Newtown to get Mr. Woodley standing to my right. Woodley, can you state your name before, please? James Dennis Whitney.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court.
Why?
No, my turn.
Sure.
The very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors, you are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing. Without notice to any side, I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing. Mr. Bennett, if I had had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard.
This explanation directly addresses the accusation of unequal access. The judge says the court could have modified the defendant's bond based on the magistrate's decision and the applicable court rule without conducting this hearing, but instead scheduled one so both sides could present their positions. That distinction is critical. A judge may strongly object to an attorney's accusation, but the defendant should not lose liberty simply because counsel angered the court. The defense also says it recently received discovery and has not had sufficient time to review it. Rather than ruling immediately while tempers are high, the judge is preparing to provide additional time for counsel to examine the material and develop a coherent response to the prosecution's request. This is both a procedural safeguard and a way to ensure that the final bond decision rests on evidence rather than emotion. Do you think the attorney raised a legitimate concern in the wrong way? Or was the allegation of favoritism completely unsupported from the beginning?
Opportunity to be heard. Now, having said that, so maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all. That is all. Noon tomorrow.
The hearing concluded without an immediate ruling on the prosecution's request to modify the defendant's bond. Instead, the judge adjourned the matter until May 10th at noon and ordered all parties to appear. The court gave two clear reasons. First, defense counsel would receive approximately 18 additional hours to review the newly obtained discovery and prepare a coherent argument against the prosecution's request. Second, the judge wanted to ensure that the defendant would not be punished because of counsel's accusation that the court favored prosecutors. Although the judge described that accusation as one of the most ignorant and insulting statements heard from an attorney during nearly 25 years on the bench, the court expressly stated that decisions would not be made out of anger. The broader takeaway is significant. Courtroom advocacy can be forceful, but allegations questioning judicial impartiality must be supported and presented professionally, especially when a client's freedom is at stake. Was the adjournment the fairest solution, or should the judge have ruled immediately? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.